Good morning, everyone. Welcome to the Consumer Financial Protection Bureau's field hearing about the CFPB's Know Before You Owe mortgage forms, which is being live streamed and recorded from downtown Boston, Massachusetts. The Consumer Financial Protection Bureau is an independent federal agency whose mission is to help consumer finance markets work by making rules more effective, by consistently and fairly enforcing those rules, and by empowering consumers to take more control over their economic lives. My name is Zixta Martinez. I'm the Associate Director for External Affairs at the CFPB. Today's field hearing, as I noted, is being live streamed on our website at consumerfinance.gov, and you can follow CFPB on Twitter and Facebook. You can also file a consumer complaint at consumerfinance.gov, by U.S. mail, by fax, or by calling 1-855-411-2372. Let me spend a moment telling you about what you can expect at today's public field hearing. First, we are honored to be joined by two special local guests that will be kicking off the field hearing. In just a minute, you'll hear from Massachusetts Commissioner of Banks, David Cotney, and State Treasurer Steve Grossman. Then you'll hear from the CFPB's Director, Richard Cordray, who will provide remarks about the Bureau's work, which, as I noted, we call Know Before You Owe mortgage forms. Following Director Cordray's remarks, the CFPB's Deputy Director, Steve Antonakis, former Commissioner of Banks in Massachusetts, will lead a discussion with a panel of experts. Deputy Director Antonakis will be joined by Richard Horn. Let me start by introducing Commissioner Cotney. David Cotney has served as the Massachusetts Commissioner of Banks since November 2010. His office oversees the supervision of over 200 banks and credit unions in Massachusetts, which combined total assets in excess of $335 billion, as well as over 8,000 non-depository licensees. He is an active contributor to consumer financial protection efforts, both in Massachusetts and nationally. He serves on the board of the Massachusetts Financial Literacy Trust Fund. He's the vice chairman of the board of directors of the CSBS and is chairman of the state liaison committee of the FFIEC, the Federal Financial Institutions Examination Council. Commissioner Cotney.
Well, good morning, everyone, and thank you for the introduction. I want to welcome everyone to this field hearing by the CFPB entitled Know Before You Owe Mortgages. Thank you to Director Cordray and the CFPB for planning this event. I am pleased to welcome you all to Boston. And to my former colleague, now Deputy Director of the CFPB, Stephen Antonakis, welcome home. Massachusetts has paved the way with many firsts, which were later adopted at the federal level. And I'm not just referring to Obamacare. Banking and bank regulation traces its roots in Massachusetts to February 7th, 1784, when the charter for the Bank of Massachusetts, the forerunner to the Bank of Boston, was signed by Governor John Hancock and Senate President Samuel Adams. Massachusetts passed the first credit union law in the country in 1909, which serves as the basis for similar laws in other states and the National Credit Union Act. In the areas of consumer protection, the Massachusetts Truth in Savings Law predated the federal statute by 7 years. Massachusetts passed community reinvestment and home mortgage disclosure requirements several years before the federal acts. But perhaps most importantly, in 1966, under the leadership of then Commissioner of Banks John Hines, former mayor of Boston, you can go to the Hines Center down the road, the Commonwealth passed the nation's first truth in lending law. It became the model for the subsequent federal law. And today, Massachusetts is one of 5 states to be exempted from the federal Truth in Lending law and Regulation Z due to our comprehensive Truth in Lending compliance program. The final regulations issued today by the CFPB are much needed and, in my opinion, long overdue. I commend the CFPB on its Know Before You Owe campaign, both in terms of the goal of simplification of disclosures and the process the agency has undergone in soliciting public input. This campaign was no small undertaking, and the efforts by the CFPB are of value to consumers to help them understand and compare the terms of a mortgage, to the industry, who must understand how to properly comply, and to regulators who must interpret and enforce the regulations. The division and other state regulators appreciate the many initiatives of the CFPB, and in particular, the CFPB's willingness to engage and listen. Most often, we see the trends and problems first and at the state level and can offer valuable insight to policymakers in Washington who have a national perspective. Today's field hearing is a testament to your commitment to listen and not just to speak. We look forward to continued and coordinated consumer protection efforts between the states and the CFPB. Thank you again to Director Cordray and to the CFPB for providing us all the opportunity for this important public field hearing. Thank you.
Thank you, Commissioner Cotney. Next, I will introduce State Treasurer Steve Grossman. Since assuming the office of the Treasurer in early 2011, Steve Grossman has overseen the implementation of several key initiatives that capitalize on his vision for a business-oriented and transparent state treasury. He created the Small Business Banking Partnership, a program that encourages increased lending activity to small credit-worthy businesses by depositing Treasury Reserve funds of up to $10 million apiece in Massachusetts community banks. He advocated for the creation of a new financial literacy trust fund, which uses privately donated funds to educate targeted populations about savings techniques, consumer protection measures, and the power of long-term financial planning. Treasurer Grossman has also made openness and transparency a hallmark of his administration, taking steps to put the Commonwealth's checkbook online and putting scores of contracts out to competitive bid. Treasurer Grossman.
So I had occasion to read a lot of what Rich Cordray has written and said, because he speaks regularly. And there's one phrase that he has used over and over again that it seems to me to be at the heart and soul of what this is all about. He said, financial education equals individual empowerment. And that's not a novel idea, but it is an idea that is at the heart and soul of who we are today, what we stand for, and the kind of leadership we want to provide. Financial education equals individual empowerment. Leave no one behind. Level the playing field and provide for every person, every consumer, every individual, every family, a pathway to financial education, financial literacy, financial empowerment, which lifts each person up, enables them to realize their full potential. When I was running for state treasurer back in 2010, I had the occasion to read a study, a seminal piece of work done by State Senator Jamie Eldridge here in Massachusetts, as well as Tina Brooks, then Undersecretary. This is the work of the Asset Development Commission. And it suggested that 40% of the people living in Massachusetts, and I suspect most other states, were afflicted by financial challenges, in many cases one paycheck away from financial disaster. And if we think about all the challenges that families and individuals face in our society, financial matters, financial education, financial disempowerment are probably at the heart and soul of many of them. So frankly, as I looked at the arc of Rich Cordray's career, his work as state treasurer in Ohio back in 2007, back in 2008, before he was elected Attorney General and became a warrior on behalf of the consumers of the state of Ohio, I saw that he too created a small business banking partnership, pouring hundreds of millions of dollars into small business loans that empowered small business owners at every level of our society. I mean, we're talking here about women-owned businesses, minority-owned businesses, immigrant-owned businesses, businesses owned by veterans. Small businesses are the job creators. And if we can create an environment in which financial education and financial literacy are at the heart and soul of everything we do, so many of the challenges families face may go away or at least be diminished. Think about those older adults and all the things that happen to them, the scams that are perpetrated on older adults because they simply don't know and don't have the ability to ask the right questions because they've never been taught. But it's not only older adults that are afflicted. It's our fellow citizens, so many of whom have been affected by the mortgage crisis, the foreclosure crisis. And what would have happened had we made financial education part of our educational system K through 12? If we're teaching young people 3 years old to save a nickel or a dime a week on Sesame Street, then certainly we can incorporate into K through 12 education, financial literacy, financial and individual empowerment. And those are some of the initiatives that Rich Cordray and his team have incorporated into their seminal work, which I hope you've all read, in terms of how we incorporate financial education into public education across the country, across the length and breadth of this land. And when I became state treasurer, I looked at what you had done, and I said, we've got to pilot things that are built on your model. You've done a great deal of research. We don't need to reinvent the wheel here in Massachusetts. David Cotney is a member of the board of the trust fund. My colleague Leanne Martin-Fay is here. She's been head of financial education in the state treasurer's office. We have the state's office of financial education and financial literacy at the state treasurer's office. So we essentially said there are 4 key populations that we need to work on and work with. First, K through 12 students. Well, we've already talked about that, and we know how important that is. And we have tried in a pilot program. The legislature gave us $250,000 this year, and we've put a pilot program into 11 high schools in our gateway communities, our older industrial cities, to create curriculum materials. These are math teachers, social studies teachers, guidance teachers, working in a team teaching environment to bring financial education and literacy so that one day every high school student will graduate with some basic knowledge, and every young person, K through 12, will have that opportunity. Low and moderate income families. We run money conferences around the state, and we no longer restrict them just to Springfield and Boston. We now are dedicated to having a money conferences every one of our 26 gateway communities, so that those people who live in our old industrial cities characterized by low levels of educational attainment, low levels of economic attainment, will have the tools that they need to compete and win and be the family members, the parents, and the workers and the business owners that they need to be. Veterans. We've had 37,000 veterans who have come back from Afghanistan and Iraq. We have almost 400,000 veterans in this Commonwealth. And we think those people who have worn the uniform of this country and taken it off and served with distinction should have some help. So we're going to be running the first ever military or veterans money conference next spring in March, in which we're going to invite veterans and military families from all over the Commonwealth to come together at a central location at a community college. Absolutely critical to those families. And that money conference is jointly sponsored by the Treasury, by the Adjutant General, the Major General who runs the National Guard, Scott Rice, and by our Secretary of Veterans Services, Coleman Nee. K through 12 students, low and moderate income families, veterans, and older adults. Those are the 4 key populations. And if you look at the work that you do, your work is dedicated to those 4 key constituencies. So I'm proud and honored to follow in your footsteps, Rich, both as state treasurer working on small business matters and providing capital and access to capital to small businesses, and to follow in your footsteps as the chair of the Financial Literacy Trust Fund here in this Commonwealth to make the pioneering steps you have taken, you and all of your colleagues have taken, to make that vision a reality. No citizen of this Commonwealth, no citizen of this country should get up in the morning and feel like they are lost, that they don't understand how credit cards work, that they don't understand how compound interest works, that they can't ask the right questions of a mortgage lender, and all the other things that go into the whole subject of financial education, financial literacy, financial empowerment, which equals individual empowerment. So thank you for your bold, innovative, pioneering and dramatic leadership on this whole basket of issues. I think you are changing the conversation nationwide. You've certainly shown us the way here in Massachusetts. I am proud to have stood in your footsteps as state treasurer, and I'm proud to work with you, as is David and so many of us, every step of the way. I know this will be a very important opportunity. David used the word listen at least a couple of times in his remarks. He reminds me of my father's best piece of advice. My father said, "Steve, you were born with one mouth and two ears. Use them in that proportion. Be a better listener than talker." Today is a great opportunity for us to do some serious listening to some experts and, equally important, citizens. Because when you listen to the citizens who go through the challenges and the heartache, which sometimes have been caused by a lack of financial empowerment, a lack of financial literacy, a lack of individual empowerment, then you know how important a priority this should be for every elected official at every level of our society. Thanks so much for listening.
Thank you, Treasurer Grossman. I'm now very pleased to introduce Richard Cordray. Prior to his current role as the CFPB's first director, Richard Cordray led the CFPB's Enforcement Office. Before that, he served on the front lines of consumer protection as Ohio's Attorney General. In this role, he recovered more than $2 billion for Ohio's retirees, investors, business owners, and took major steps to help protect consumers from fraudulent foreclosures and financial predators. Before serving as Attorney General, he also served as an Ohio State Representative, Ohio Treasurer, and Franklin County Treasurer. Director Cordray.
Thank you. I knew that coming here today, it was going to be special to come to Boston for this field hearing, and the city carries for me resounding and loud echoes in our field of work. It's good to have heroes in life. They can both inspire and sustain you. And one of my heroes was the original consumer advocate in this city a century ago, Louis Brandeis, who fought for reasonable regulation of the public utilities, fought to tame the sprawling trusts, fought for savings bank life insurance, which was one of the many innovations, progressive innovations that the Commonwealth of Massachusetts has presented to this country. Followed many years later by another original and notable consumer advocate from this city, then Professor, now Senator Elizabeth Warren, our friend and former colleague, working with her at the Consumer Bureau. At the same time, it's marvelous for me to hear David Cotney talk about a banking statute that was advanced by Senate President Samuel Adams and signed into law by Governor John Hancock. That gives me a sense of the deep history here. And I very much appreciate Treasurer Grossman's remarks on two subjects near to my heart. It was one of the joys of my time as state treasurer, Mr. Treasurer, to work on small business lending and to be able to go and see small businesses creating jobs and how well and expertly they did that and how much of a difference it made to so many people's lives, and to feel that I had a small part in that was very satisfying. At the same time, financial literacy is a bedrock issue for this country, and it's a challenge we have to meet. It's been a shame, I've said this many times, a shame and a scandal that in this country we do so little to prepare our young people to go out in life and to be able to manage their affairs in a free market economy where individuals have to stand on their own and make their own choices. They need to have a foundation of knowledge and education to do that. So let me turn to the subject for today. Finally, I did want to mention before I do that, it's special here to be in the home state of Steve Antonakis, who is our Deputy Director of the Bureau. He has been a strong leader for us at the Bureau since before I arrived there in January of 2011. He's become a trusted confidant and partner to me, and we're very pleased to be among so many of his friends and colleagues here in the Commonwealth of Massachusetts. So now to the matter for today. The dream of having a place of one's own has long been part of our American way of life. For many people today, even after all the heartache we've experienced in the past 5 years since the financial crisis and the collapse of the housing market, owning a home still means something special, and always will. It means a solid and certain foundation of stability and even a kind of permanence. It means the prospect and the tangible opportunity to climb the economic ladder. It means putting a stake down on a better life. As T.S. Eliot said, home is where one starts from. As the housing market gains momentum, I'm glad to say that it's doing that, and a growing number of consumers emerge from being underwater on their homes, people are feeling encouraged. They are once again looking to find a way to realize that dream in their own lives, to have a place of their own to put down roots, raise a family, and retire someday. Last January, we put in place new protections to improve the functioning of the mortgage market by preventing creditors from extending loans to consumers who do not have the ability to repay them. Today, we're putting in place new measures that ensure consumers have the information they need when they need it. By implementing rules that allow people to better understand the terms of the mortgage deal they're being offered, the Consumer Bureau will help them shop around for a mortgage that makes sense for them. These rules give greater control to consumers so they can take charge of the decision they are about to make. The end result will be a more competitive and user-friendly shopping experience where consumers, as we say, can know before they owe. When people take the plunge and decide to buy a home, they usually put pretty careful thought into what kind of place they want and where it's located. They consider their deal breakers and their wish lists. They may be looking for a house with a garage, or lots of sunlight, or maybe a backyard where their children can play. To see what is out there, they peruse websites, visit open houses, and scour neighborhoods, in particular school districts. Then there's the whole financial side of the transaction. Buying a home, after all, is not an everyday decision. It's one of the biggest financial decisions most people will make in their lifetimes. According to the latest numbers from the National Association of Realtors, our expert resource on this subject, the median price of homes purchased in the United States is now $207,000. By comparison, the median household income is about $51,000, according to the Census Bureau. It's crucial to consider the numbers carefully before making a potentially long-term commitment. For most consumers, an important element of the process is determining how much of a down payment they can afford to make and how large a mortgage they can afford to repay. To make that determination, consumers may seek advice from family and friends, financial advisors, or other sources such as the internet. Many consumers contact a mortgage originator at a bank, credit union, mortgage company, or brokerage firm. But for too many people, this is when the shopping, the calibrating, and the research grind to a halt. Consumers too often fail to apply the same thought and care to shopping for a mortgage as they do when shopping for a home. The consumer needs to be better empowered to shop around for a mortgage. People who are buying a home deserve to be the drivers of this process, not the passengers. Whether a consumer shops among multiple lenders or talks to a single lender, there are many variables to consider because not all mortgages are the same, as we have seen. Closing costs can vary from lender to lender. Fees can vary from loan to loan. Failing to understand these differences and make good choices about them can have lasting consequences for buyers and their families. Consumers need to assess not just the interest rates and the closing costs, but the mortgage insurance costs, the application fees, and how the interest rate might change over the life of a loan. In addition, buying a home may involve purchasing services from multiple parties, such as realtors, title companies, insurance providers, and others. Those costs should be considered carefully and evaluated against the competition and in light of the options available. Most important, a consumer needs to understand the risks that may be associated with the terms of different mortgages. During the years leading up to the financial crisis, too many consumers took out mortgages with risky features they did not understand. Features like teaser rates or interest-only periods, which could lead to large increases in monthly payments down the road. Getting stuck with the wrong mortgage can cost tens of thousands of dollars over the life of the loan. It can even bring about a foreclosure, which costs a family their home and damages their prospects for buying another one anytime soon. Too many Americans learned this lesson the hard way during the financial crisis. And we all saw the broader consequences that can result for everyone in this country when these bad decisions pile up. The sharp decline in home prices, the lasting problems in the job market, and the severe drop in the value of our investments and retirement savings. Today, the Consumer Financial Protection Bureau is putting in place rules that will help consumers shop around for the right mortgage. We're doing this by overhauling the mortgage disclosure forms currently required by federal law and putting in their place 2 simpler, easy to understand, know before you owe forms. For decades, the Congress has tried to help consumers get the information they need to decide what is best for them when they shop for a home by requiring lenders to disclose certain information. Generally, within 3 business days of applying for a loan, federal law requires mortgage lenders to deliver 2 different disclosure forms to consumers, an early truth in lending statement and a good faith estimate. At the closing stage of the transaction, also, federal law generally requires that 2 different disclosure forms again be provided to consumers, a HUD-1 settlement statement and, most of the time, a final truth in lending statement. In the Dodd-Frank Act, Congress instructed the Bureau to integrate these disclosures to avoid the confusing duplication that was occurring at each stage. Accordingly, under our new rules, consumers would no longer receive all these overlapping forms. Instead, consumers will get a single form shortly after applying for a loan, known as the loan estimate, and they will get 1 form shortly before finalizing a loan, known as the closing disclosure. These new forms will enable consumers more readily to spot crucial information that demands their focus, such as the interest rate, monthly payments, and total closing costs, as well as any special risk factors that could lead to payment increases over time. We have been working on this project for more than 2 years. Today's forms can very much be credited to your senator and my friend Elizabeth Warren. Unfortunately, she's not able to join us today because she is in Washington fulfilling her senatorial duties. But she is certainly here in spirit, and we thank her for everything she has done, not just on this Know Before You Owe project, but also to conceive, secure, and build up our new agency that is dedicated to protecting consumers in the financial marketplace. The key to this project was to figure out how to make these forms work for consumers. The best way to do that is to get feedback directly from consumers and industry. So we went across the country, visiting dozens of cities and interviewing a large cross-section of people in a rigorous qualitative consumer testing process. We conducted testing with industry as well because we wanted to see how people who work in this business would use the forms and explain them to consumers. We developed prototypes, and then we kept working and working to improve the forms to arrive at today's final versions. We found that the interest in our efforts was enormous. For example, when we supplemented our testing by putting different versions of our prototypes out for the world to see, they received more than 27,000 comments on our website. One of our main goals with the loan estimate and closing disclosure is to improve consumer understanding. With a simple accounting of payments and fees, these new forms help consumers see just what they're getting into, the terms of the loan, the obligations, and how they could change over time. We've made it a point to present the information in plain language, in a format that's easy to follow, where the costs and risks of the loan are made clear. The key information is labeled in an obvious manner so consumers can come to grips with questions like, can this amount increase after the closing? And right there, up front on the first page, consumers see what they need to see the most: the loan amount, their monthly payments, taxes, insurance, other property costs, and the total cash required to close the loan. After we proposed the forms, we conducted further testing, including a quantitative validation study in which we gave some consumers the current versions and others the new ones, and then compared their ability to use them. Test results showed that participants who used our new forms understood them better in key respects. Some of the improvements were substantial. For example, consumers using the new forms provided more correct answers about a sample mortgage, improving their scores by 29%. Other changes were even more dramatic. By identifying the loan amount in big, bold font and making it one of the first things a consumer sees, consumers were far better able to recognize it. Their performance on this point improved by as much as 75%. And for consumers presented with complicated loan products like adjustable rate mortgages, their ability to compare the highest possible total monthly payment between 2 loans improved by 98%. Our second major goal is to improve the opportunities for comparison shopping. Consumers will first get the loan estimate within 3 days after they apply for a loan. They can take this form, apply for another loan elsewhere, and then make a direct comparison between the 2 forms. They will be able to see, for example, who is providing better rates and cheaper application fees, and who is quoting better pricing on insurance costs. And consumers will be better able to weigh those price differences against the different terms each lender is offering, such as when interest rates are likely to adjust on one loan compared to the other. Consumer testing again showed that our redesigned forms consistently outperformed the current disclosures, with people performing as much as 42% better when it comes to assessing competing offers. When consumers have decided on a loan, our new rules also require that they must get the closing disclosure 3 days before the closing occurs. It summarizes the final loan terms and costs and also provides a detailed accounting of the transaction. Before people arrive at the closing, they can compare this form to their loan estimate to see if anything has changed. Our form makes that comparison very obvious, which minimizes the potential for bait-and-switch increases in rates, fees, or settlement costs. And for certain changes that are especially material, consumers must be provided advance notice at least 3 days before the closing. This 3-day window allows consumers some time to process the information before the transaction is finalized. It also gives consumers time to negotiate over any changes that may have occurred. Here, too, our forms performed 28% better among actual consumers than the current forms in being able to compare the original loan offer to the final terms of the deal. The underlying premise for both the loan estimate and the closing disclosure is that consumers will be better able to understand the mortgages they are buying and the costs they are paying. They will be better able to shop for the right mortgage that suits their needs. The new forms make it easier for consumers to own a home by helping them own the process for buying a home. At the Consumer Bureau, we believe our responsibility does not end with finalizing new rules. We must make sure that lenders put these changes into place effectively. So as we look ahead, we will work with industry to help them implement the provisions of the rule, and we will work with consumers to make sure they understand and benefit from these new improvements. As part of this process, we're also very enthusiastic to work with all stakeholders to improve the overall mortgage closing experience. For a long time, many have come to agree that the stack of closing documents is way too large. Some of these forms were intended to help consumers better understand the costs and risks of their mortgages. Others were devised by lenders as defensive measures to minimize the prospects of future litigation. Still others represent federal, state, and local government requirements, some of which may have become outmoded. The undeniable result is information overload, too much to absorb during the closing process. This burdens lenders without helping consumers. Indeed, it's counterproductive insofar as it causes consumers to zone out and sign documents without properly evaluating the information that is critical to understanding the largest financial transaction of their lives. And many leave with a new anxiety as they find themselves wondering what was buried in the mound of paper that may create some nasty surprise in the years ahead. So as part of our Know Before You Owe initiative, we're making a commitment to work with industry to improve the mortgage closing experience for consumers through technology. We believe that e-closings could represent a positive development along these lines, and we want to know more about how we can foster innovation in this area. By reducing the visual tyranny of the stack of closing documents, we can focus more attention on the new user-friendly closing statement, which may enable further advances in consumer education and understanding. We recognize that one thing we can do is work to help remove obstacles to this approach, and we will do so. We also want to work collaboratively with industry, with consumer advocates, and with government officials to take a close look at all the closing documents and identify how they can be reduced or eliminated if they're no longer adding value to the mortgage transaction. In addition, we're working to help inform and empower consumers earlier in the mortgage process. We will soon be rolling out new tools and resources on our website to help consumers better understand the mortgage market and the choices they should be considering carefully as they think about buying a home. You can go to consumerfinance.gov/owning-a-home and sign up for our email list to receive more information as it becomes available. Finally, we're also aware that some companies are creating electronic smart versions of various mortgage documents and are looking into creating smart versions of the information contained on the new loan estimate forms. We're asking industry participants, especially those already pursuing new technological advances, to reach out and join in our efforts to improve the mortgage origination process for the benefit of consumers and industry alike. So today is a new beginning. With the rule writing process now complete, we're allowing a very reasonable time frame, 21 months, for industry to implement these changes. During that period, as I just sketched out, we will continue our ongoing Know Before You Owe efforts to improve the mortgage market and the mortgage closing experience for consumers. This is the right priority for the Consumer Bureau and for the country, so we will keep at it. Thank you.
At this time, I'd like to invite Deputy Director Steve Antonakis, Richard Horn, Senior Counsel of the CFPB's Office of Regulation, and our distinguished panelists to please join the stage. Following the panel discussion, we'll kick off the audience participation portion of the field hearing. The audience participation portion of the field hearing provides audience members with the opportunity to share their stories and observations about what they're hearing and seeing in their own communities in connection to consumer finance, or to provide feedback about the panel discussion and remarks that we've just heard. Today's audience includes community leaders, advocates, industry representatives, and of course, consumers as well as public officials. We're also pleased to welcome bicameral congressional staff from across the New England states, including staff from the offices of Representatives Keating, Kennedy, Tierney of Massachusetts, Senator Blumenthal of Connecticut, Congresswoman Shea Porter of New Hampshire, and Congressman Langevin of Rhode Island. Thank you all for joining us here today. Let me introduce our panelists. Steve Antonakis joined the CFPB in November of 2010 as the Assistant Director of Large Bank Supervision and was named the Associate Director for Supervision, Enforcement, and Fair Lending in June of 2010, CEFL, as we like to call it. His background includes more than 2 decades as a financial services regulator, much of it here in the state of Massachusetts. In September of 2010, he was also named CFPB's Deputy Director, along with his continuing role as Associate Director for Supervision, Enforcement, and Fair Lending. Richard Horn is Senior Counsel and Special Advisor in the Office of Regulations at CFPB. Before joining the Bureau, he was Senior Attorney at the Federal Deposit Insurance Corporation in the New York Regional Office. At the FDIC, he supported the FDIC supervision staff on both consumer compliance and risk management. Our panelists include Patricia McCoy. She's with the Insurance Law Center. She's director there, and a professor of law at the University of Connecticut School of Law. We have Willard Ogburn, Executive Director of the National Consumer Law Center. Marietta Rodriguez, National Director, Homeownership and Lending, NeighborWorks America. We have Bernie Wynn, President and CEO, Boston Firefighters Credit Union. Michelle Korsmo, CEO of American Land Title Association. And Larry Chatu, Assistant General Counsel and SVP of Bank of America. Steve and Rich, you have the floor.
Great. So, good morning, everyone. It is, in fact, a distinct pleasure, a special pleasure for me to be home. Home, I might add, of the world champion Boston Red Sox. Also, indulge me while I recognize 2 folks in the audience. Former Senior Deputy Commissioner of Banks, Ted Geary, who was my first boss at the Division of Banks for many years, and also former Commissioner Andy Calamari, who hired Commissioner Cotney, hired myself, and hired the current Comptroller of the Currency, Tom Curry, as well. As was discussed already today, the focus of today's hearing is TILA RESPA integration, an effort to provide a more meaningful mortgage experience for consumers. So let me speak to that briefly before we have discussion from our esteemed panel here. The Bureau was directed by the Dodd-Frank Act to integrate TILA and RESPA, and the purpose primarily, as I mentioned, of the disclosures is to aid consumer understanding. So the Bureau wanted to ensure consumers could use these forms. We conducted qualitative consumer testing both before and after issuing our proposed rule. In total, 17 rounds of qualitative usability testing in 14 locations with 164 industry and consumer participants. The Bureau also supplemented this qualitative testing with the Know Before O project, including an online tool and blog posts, over 150,000 visits to the Know Before You O website, and over 27,000 public comments and emails about the prototype disclosures. After the proposal, to validate the qualitative usability testing results, the Bureau conducted a quantitative test of the Bureau's disclosures in 20 locations across the country with 858 consumers. We also tested the current disclosures to compare performance between the existing and the Bureau's new forms. The quantitative test showed statistically significant better performance than the current mortgage disclosure forms, specifically 28% overall improvement over the current forms. Examples of areas of specific improvement included 98% improvement in the ability to compare the highest possible total monthly payment between two loans, 75% improvement in identifying the cash to close, 71% improvement in understanding final loan terms and costs, 47% improvement in identifying changes to monthly principal and interest payment amount, 32% improvement in identifying negative amortization features, and a 21% improvement in identifying the APR. All of the consumer testing indicates the Bureau's integrated disclosure forms perform better at helping consumers understand their mortgage transactions from application to closing. The integrated disclosure forms will be required for mortgage applications received on or after August 15th of 2015. In an effort to support rule implementation and ensure industry is ready for the new disclosures, the Bureau will assist in implementation. We will have staff engage with industry at a variety of venues. Also, we will publish an easy-to-understand summary of the regulation and other related resources designed to support compliance. The guides will be particularly helpful to smaller lenders with limited staff for compliance. The guides and other related resources will be made available on the Bureau's website. Now it is my distinct pleasure to introduce Richard Horn, who will present the new disclosure forms.
Thank you, Steve. With all due respect to Director Cordray and Deputy Director Steve Antonikis, I have to say I've had the best job at the CFPB for the last 3 years. Because I've had the opportunity to work with consumers and industry stakeholders across the country on the new TILA and RESPA integrated disclosures. I also want to thank the public for providing us with such excellent feedback through our Know Before You Know initiative. And I feel like I should also note that we did conduct both qualitative and quantitative testing here in Massachusetts. So now it's my pleasure to introduce you to the new disclosures. Here is your loan estimate. It replaces the initial truth in lending statement and the good faith estimate. I'm going to flip through to the closing disclosure. This is your closing disclosure, which replaces your final truth in lending statement and the HUD-1 settlement statement. The loan estimate will be provided to consumers within 3 days after application, and the closing disclosure will be received by consumers 3 days before closing. Some of the highlights of the new forms are that the information consumers really care about is on page 1. Oh, there we go. Back to the loan estimate, so I can show you this. We learned about the information consumers really care about through our extensive consumer testing and research on mortgage disclosures. Page 1 contains the most readily understandable information for consumers, giving them everything they need to compare loans, evaluate the affordability of a loan, identify potential risks, and see how high their monthly payments can increase. Consumers will be able to see whether their interest rates will also increase and whether their loan amount will increase. You can see this under the Loan Terms tab under page 1, and it's in response to a very plain language question which says, will this amount increase after closing? And they will say a yes or a no in bold font, so that is readily visible and understandable for consumers. Also, regarding the affordability of a loan, page 1 of the forms also tell consumers how much cash they will need to bring to closing. A loan does not only include the credit transaction, but also includes the real estate transaction, and consumers should see both together in one number. One other important feature about the forms is that we designed the loan estimate and the closing disclosure to match. Right now, the good faith estimate and the HUD-1 settlement statement don't match, and we wanted consumers to be able to easily compare their estimated and their final numbers. So you can see here that the loan estimate and the closing disclosure, page 1s, match almost exactly. The other important feature is that we wanted to match the closing costs, so consumers can compare their estimated and their final closing costs. So page 2 has an organization of closing costs, which is separated between loan costs and other costs, which matches the organization of closing costs on page 2 of the closing disclosure. At consumer testing, consumers frequently put the forms side by side to go down line by line and compare the items so they could easily see what changed. And we saw that those results in our quantitative testing results as well, with the improved performance for comparing estimated and final numbers. You can see the new disclosures and find more information on our website. I couldn't go into all the detail about all the improvements these disclosures make for consumers at this field hearing today, but all the information about our consumer testing, all of the consumer testing reports that were produced by our consumer testing specialist, Climate Communication Group, are on our website, as well as more information about our forms. And we also have created forms in Spanish as well for Spanish-speaking consumers to facilitate understanding for consumers who don't necessarily speak English or conduct their mortgage loan transaction in English. So thank you very much.
Great, thank you, Richard. So at this point, we will now invite our panelists each to give 2 or 3 minutes of opening remarks, and we'll start with Pat McCoy.
Very good. Thank you so much for having me here to testify today. First, we wouldn't be here without the tireless work of several people, of Richard Horn, Kelly Cochran, Megan Typus, Pamela Blumenthal, and Susan Kleiman, who's in the audience. Bravo. In my brief remarks, I'd like to highlight the strides that these forms make and then share a few thoughts on a couple of challenges. When the 2008 financial crisis hit, it became obvious that the old TILA and RESPA forms had failed on several counts. In particular, consumers did not receive the information that they wanted or needed in the forms. In particular, they were not told what they really needed to hear, which was how high their payments could go with products such as adjustable rate mortgages, negative amortization mortgages, balloon loans, and products with prepayment penalties. As a result, millions of unsuspecting borrowers entered into mortgages that they did not understand and could not afford. We know this harmed consumers, but it also harmed our financial system as a whole. We can't afford that again. These new forms tackle these problems head on. Now the back-end risks are obvious, and the test results show it. In addition, I'd like to stress the accomplishment of the testing. 17 rounds of qualitative testing, and then quantitative testing on top of that, with comments from tens of thousands of people. That's amazing. No federal agency had ever done this before. And when those online comments came in from consumers and industry, a lot of people suggested possible tweaks, which the Bureau could then test, and it did. And that crowdsourcing helped improve the forms tremendously. So let me now move on to a couple of challenges ahead. This rule has important protections against bait and switch schemes, but some more could be done. Today we have a world of risk-based pricing where it is difficult for weaker customers to get binding interest rate quotes before closing. In part, lock-in commitments are rare for non-prime customers. There is the risk that lenders could circumvent the limits on closing costs by hiking the interest rate 3 days before closing. I think there's a technological solution to this problem. Today, with automated underwriting, it's possible for a lender to give a relatively firm interest rate quote after pulling the customer's credit reported application. Now, obviously, the customer's qualifications would have to be verified, but harnessing technology this way could help establish guardrails that could further cut the risk of bait and switch schemes. The other challenge is data collection. Right now, it's difficult to understand trends in closing costs and the degree of competition in that market. In the future, it will be important for the federal government to capture detailed closing cost data on individual loans. This sunshine will help consumers, but it will also help lenders. For example, some lenders have expressed concern about their ability to compete under the 3% cap on total points and fees for qualified mortgages. Transparency about the competitive effects would help shed light on these concerns. Thank you.
Thank you, Pat. Willard.
Thank you for inviting me. As you know, I'm a big fan of the Bureau, and I want to congratulate you on making a great many very substantial improvements in the disclosures, especially with the clarity that is there and with the emphasis on consistency among lenders, but also consistency between the loan estimate disclosure and the closing statement disclosure. I mean, for 20 years, people have wanted to combine these various disclosures, and you finally pulled it off. And together with other CFPB substantive rules, the consumers are much better off. Industry has clearer parameters and guidelines, and the opportunity to take advantage of consumers is significantly diminished. Among all these improvements, there are three significant concerns that remain. I'm sure you're aware of them. The first is that the APR, the annual percentage rate, is not prominently disclosed on the first page where consumers are most likely to look. Instead, prominence is given to terms like cash to close, which is certainly important, but for one to compare the pricing of two different loans, that often is not very helpful at all, and the APR is the singular most important shopping tool there is. Even if one doesn't understand exactly what the APR is, you know that a lower APR is better. And the second is related, whether that APR is disclosed on the first page as I would like to see it, or on the third page as in the new forms, it's really important that that annual percentage rate be accurately calculated. The Federal Reserve Board had proposed in 2009 to include all the closing costs and other costs and fees in that calculation, and the original proposal from the CFPB did the same in 2012. But unfortunately, the forms as they're now constructed or will be constructed allow some costs, closing costs, and even inflated and padded title insurance to be excluded from that calculation. So it makes shopping much more difficult. And I would think that disclosure would be helpful all the way around. I know you're committed to looking at that in the future, but it is an egregious omission currently. And then finally, I really herald and applaud the emphasis on consistency between the loan estimate and the closing disclosure. But as Pat mentioned, there is still the opportunity that when you come to closing, there'll be differences between what you see at closing and what occurred 3 days before. And while that loophole's been vastly narrowed, it's still a loophole. There's still an opportunity from bait and switch, and that really deserves careful scrutiny. You've made a lot of important and vital improvements, especially when combined with things like ability to repay, and it comes with the obligation to be vigilant and be open to further changes.
Great, thank you. Marietta?
Thank you, Director Cordray and your staff for inviting NeighborWorks America to participate in today's important field hearing. Your team's work over the last 2 years has been critical in protecting potential homebuyers across the country. For those of you who are not familiar with NeighborWorks America, we're a national nonprofit established by Congress 35 years ago to make it possible for lower income people to live in affordable homes and in safe, sustainable communities. NeighborWorks America supports over 240 local nonprofit affiliate NeighborWorks organizations serving more than 300,000 individuals each year. Last year, NeighborWorks organizations provide homeownership education and counseling to over 120,000 individuals and help create 15,000 new homeowners. It's from this experience, from our network from which I speak today. We know that homeownership education and counseling can provide a real impact for homebuyers. A peer-reviewed research by Neil Mayer and Associates released in March found that homebuyers who worked with NeighborWorks organizations before they bought were nearly 1/3 less likely than those who did not receive assistance to fall behind on their mortgages for 90 days or more in the first 2 years of origination. We also know that people who want to buy a home, but they think the process is confusing. Today, NeighborWorks America is releasing the results of a new survey on housing attitudes. The National Telephone Survey of 1,000 adults conducted by Winmere Communications between September 23rd and 26th revealed that 88% of those surveyed still rank owning their home as an important element of prosperity and stability and would call the American dream. But at the same time, 75% of those agreed that the home buying process is complicated and very complex. The two new forms, the loan estimate and the closing disclosure, go a long way in simplifying that process and empowering the home buyer to compare mortgage products. But most buyers don't understand that there are various mortgage products that can be compared, and some of the prepaid costs prohibit true shopping because folks have to prepay for their credit reports and other prepaids. We do think this goes in a long way, and we thank the CFPB for their important work and you're doing in making this very complex process easier for the average person to understand.
Great, thank you very much. Bernie.
Thank you. First of all, thank you, Director Cordray and Assistant Director Anthony Akers for the opportunity to be here today on behalf of the credit union industry. I'd like to begin by saying that the credit union industry as a whole embraces the concept that the CFPB stands for. The mission of credit unions and the mission of the Bureau is very similar. We're both consumer-oriented entities, and we like to keep it that way and keep our members, customers as they're called in other entities, well-informed and knowledgeable. I'd like to thank the CFPB and their staff for listening to the comments of the credit union industry, as the rule that was announced last night reflects many of the comments offered by our trade association and by credit unions across the country. The concept of simple and honest banking is a hallmark at Boston Firefighters Credit Union. We pride ourselves in doing that every single day and present our members with opportunities that are always simple and honest. Therefore, we embrace the fact that a knowledgeable member is a good customer, and to that end, once again, support what has happened and actually like the disclosures that we see in front of us. We feel that we will look good compared to some other banking and non-banking mortgage alternatives, and we feel that deals that we may have lost in the past as a result of misinformed members and misinformed customers will now come our way. But, and there's always a but, Massachusetts, being a state where the conveyance process is handled by attorneys, does put a complication into this process, and especially with regard to the 3-day window that has been created for getting the final disclosures out to individuals. I'm certainly not saying that this is impossible. I'm just saying it does add another complexity. We have situations right now where we really run to the last minute in terms of trying to meet a potential home buyer's commitment to close on a certain day. If you get involved with title-related issues or things along those lines, you can be bumping against purchase and sale deadlines. Those deadlines have just now been bumped up by 3 additional days, and possibly even more than 3 additional days, because it is going to take time for coordination between the bank or credit union and the attorney to take place beforehand and get the numbers right. So I think we have to be careful in that regard. Secondly, as small financial institutions, credit unions, and I think here I'll include community banks, often depend upon third parties to help us in these endeavors. I applaud the Bureau in coming up with the 21-month implementation cycle. I think that's going to be vital in terms of us going forward. But I feel like I need to remind you that sometimes we are dealing with multiple levels of third-party organizations in order to get these right. I use a software company to help with mortgage origination and servicing. They contract with a forms company. So we're already to a 3rd generation of business partner in terms of getting these things right, and I'd just like to remind everybody that that is the case. Finally, on the topic of just regulation in general, we are a small financial institution. we have limited resources, particularly in the ability to comply and to engage in all compliance-related activities. I urge the Bureau to continue to remember that sometimes there are unintended consequences of regulatory actions. And those unintended consequences will sometimes cause people sitting in my seat to make decisions to discontinue certain products because the regulatory compliance burden is judged to be judged not to be cost effective. Once again, thank you for the opportunity to be here today.
Great. Thank you, Bernie. Michelle?
Hi, again, I'm Michelle Korsmo, CEO of the American Land Title Association. Thank you, Director Cordray, and all of you at the Bureau for allowing us to participate in this very important hearing today. ALTA's 4,700 member companies include title insurers, agents, and real estate attorneys that both issue title insurance and conduct the real estate and the mortgage closings or settlements. ALTA members are predominantly small businesses that work every day to make sure that they're protecting Americans' most valuable investment, their home. And we know there's a lot that happens between signing that contract and that fantastic day when the homeowner gets the keys to their new home. And that's where our members come in. They're busy examining documents, going to the courthouse, looking up records, reading and understanding those documents, which is really the key to ensure that when that property is transferred, there are no encumbrances, there are no challenges potentially to the title of that home. And we offer the insurance products to protect those homeowners, to keep them in their homes if something may arise in the future. The new forms and their corresponding rule are critical to our industry. We are so grateful to the Bureau for the very open process that you've had over the last almost 3 years. And we appreciate the opportunity to participate in that process. I think there's 11 times that we've commented publicly on the new forms. We appreciate the Bureau's desire to understand what's happening on the ground by meeting with our members, both in small groups and at large conferences. And I really especially appreciate the opportunity to meet directly with Director Cordray on the concerns that we have. You're a very thoughtful public servant. We appreciate the time that you've given to this hugely important issue. While your willingness to listen, of course, to the concerns of our industry when you develop this still has presented a few things that we're concerned about in the process. The first thing our members say, though, when they look at the forms is the same thing everyone says. Very readable, very understandable. We're very optimistic about the potential that these new forms have to prevent the types of problems that led to the crisis, where too many consumers were hurt because they didn't understand what they were agreeing to, or bad actors prevented them from understanding the costs in their transaction. The reality is that changes like this come with a cost, and while there's never a convenient time to go through this type of change, we want to know that as we make our significant investments in updating our systems, training our staff, educating consumers, that all of this will result in a positive experience for the home buyer and seller. Our members are concerned with their ability to continue to compete in this new environment. As we think about the potential benefits of the rule, we're looking closely at the fact that consumers have the potential for facing delays at closings that may be costly to those consumers. Additionally, we're quite concerned that homeowners are going to be dissuaded from getting the same protection of their investment that that lenders are getting in purchasing title insurance. We appreciate greatly the extended 21-month implementation time. We think that's going to make the process much smoother as we go about learning how we can best implement this rule. At the end of the day, whether you're a consumer, a lender, a title company, a settlement agent, or a regulator, we all have the same goal: a smooth closing and a positive experience for the buyers in the transaction. We appreciate working with all of you at this table and in the industry on the implementation in the next few months. Thank you.
Great. Thank you, Michelle. And Larry?
Good morning. On behalf of Bank of America, we are grateful for the opportunity to participate on this panel discussion focused on the Consumer Financial Protection Bureau's rule to integrate various disclosure forms under the Real Estate Settlement Procedures Act and the Truth in Lending Act. Bank of America is an important provider of mortgage credit to consumers. During the first 9 months of 2013, we extended more than $71 billion in first lien residential mortgage loans including approximately $15.6 billion in residential mortgage loans to more than 100,000 low and moderate income consumers. Bank of America recognizes and fully supports the need to provide accurate and clear information to consumers, along with the need to enhance consumer protections in this area. We appreciate and join with the Bureau in its efforts to protect consumers. And at the same time, we believe that such protections should strike the right balance by continuing to allow consumers to access affordable credit to purchase their homes. Our commitment to ensuring that consumers are adequately protected and continue to have access to affordable mortgage credit is also reflected in the comment letter we submitted in November of 2012. Among other things, we provided detailed comments on the draft loan estimate and closing disclosure, where we recommended detailed revisions to the documents, the goal being to further ensure consumers can easily comprehend the terms and conditions of the mortgage transaction. The so-called all-in finance charge calculation proposal, which we believe could negatively impact consumers by further restricting their ability to obtain affordable mortgage credit, and the proposed application definition, which in our view could have the unintended consequence of overwhelming consumers with multiple overlapping disclosures during the early stages of the home shopping process. Finally, we recognize the significant changes that will accompany the integration of the new disclosure forms. Therefore, we requested that the mortgage industry be provided with sufficient time to implement the changes. And on this point, we are pleased with the effective date the Bureau has provided for the rule. In conclusion, we look forward to continuing to work with the Bureau on issues that affect our customers. We share the goal of ensuring consumers have accurate and clear information as they prepare to purchase their homes. Thank you.
Thank you, Larry, and I want to thank all the panelists for their comments today and for their participation in this important conversation that will no doubt continue. My question is to the consumer group panelists, and some of you have touched on this during your remarks already, but I wonder if you could add additional detail and context. What are the biggest decisions at the signing table that pose the most risk to consumers? Why don't we start with Marietta?
So I think some of the things that we hear consumers say at the closing table is when they're looking at all their disclosure statements, is this the same thing that I got a month ago, and how you can compare? Oftentimes, even if the disclosures raise big red flags or have questions, they're at the closing table. They've probably already packed up their home. They've given notice. They've planned moving. So stepping away from the closing table is the wrong time to pose some of those questions. So I think the biggest decision, if there is something that is not disclosed properly or is a question, is what's the risk of backing away at this point when I've already given notice and packed up my things? That's one of the biggest decisions there, is what's that benefit?
Will?
So I would agree, by the time you're at the closing table, the decision's really made for all practical purposes, for emotional reasons and practical reasons, like the moving ban is there and where the kid's going to sleep. That's why it's so important to have the early loan estimates and to have high degree of consistency between that loan estimate disclosure and the closing disclosure. It's also a reason why, as Marietta refers to, you don't want to have room for surprises when you show up 3 days later. And if there are changes, I think then there should be an opportunity to step back and reflect, not having to make an all or nothing decision when there's really no, you've already given up your lease on your apartment. You're really trapped. It's also a reason why those early loan estimate disclosures are so vitally important. If there's an opportunity to comparison shop, that's when it is, and that's why having a good, prominent, strong, and accurate annual percentage rate is really important. And it's also the time when a consumer is most likely to think, am I ready to make this leap? And in that regard, I think those early disclosures are vital, but also in the connection of other actions that the CFPB has taken, especially the ability to repay rule. So the disclosures need to be accompanied by substantive protections as well.
Just briefly, the risks that both Will and Marietta pointed to are addressed in at least large part, not 100%, but large part by the 3-day advance closing notice. That is a very important time to be able to step away, to negotiate, and to try to address surprises that may have occurred. The other thing that I don't think people had time to talk about is there now are tight tolerances on the changes in the closing cost from the loan estimate to this closing form 3 days before the closing. That also helps cut down nasty surprises significantly, and it's a big accomplishment.
Thank you.
Great. Larry, how have you seen consumer behavior and expectations change since the financial crisis and throughout the recovery? Where are we now?
So that's a great question, Rich. Let me take the first question. I think overall, the change can be summarized by a word used by Director Cordray during his opening remarks: momentum. So our market research indicates that the following trends. Number one, consumer perceptions of the housing market has evolved from extremely negative in 2008 to much more positive in 2013. There are positive perceptions and trustworthiness of lenders and brokers have improved since the second half of 2012. The likelihood of a consumer purchasing a home has significantly improved from 18% in 2008 to 31% in 2013. Similarly, the likelihood of getting a home equity line of credit is at 26% today versus about 12% in 2009. And then overall, over 50% of consumers today believe that interest rates will rise versus 29% in 2009. So as far as where are we now, we think that consumers are cautiously optimistic about the housing market. 64% still believe buying a home is a good investment. We see delinquencies are down to below the pre-crisis levels. There is an increased use of debit transactions and at the same time a decreased use of credit transactions. The rising interest rate environment has led to a focus on new purchase transactions rather than refis. So in conclusion, we think that there's generally a positive behavior, behavior and expectations by consumers.
Great. Thank you, Larry. Will, could you describe issues that you've dealt with in your experience when consumers don't understand their mortgage terms?
Sure. I think in light of the new disclosures, in particular, there's just no way around the fact that mortgages are a complex transaction. There are a lot of moving parts, a lot of different fees, a lot of variables to consider. So having the uniformity and having prominent disclosures and having details is really very, very salutary. But it doesn't disguise the fact that very few people, even a room full of lawyers, could easily be facile with the relationship between interest rates and monthly payments and points and fees and why a higher interest rate might actually be a better transaction when you consider the total cost of the loan. It's going to still be confusing. And as a consequence, I think it's going to still be somewhat difficult for people to shop and compare, especially without a prominent, accurate APR. Consumers are still going to feel they have to put their faith into somebody they think knows what's best for them. It's a difficult decision to make for anybody, including highly educated and experienced people. And that means, as we've seen in the past, which I think is what you're asking about, a lot of people getting in over their head. And so the ability to repay rule is really, really vital. And we've seen, as in the past, a lot of bait and switch, and that's been significantly narrowed by these forms and by the rules that go with the forms, but still have this little room, important wiggle room that's still there and still needs attention. So we have clarity and consistency. I don't think we'll have total comprehensibility, in the main for consumers and for most people, and so the protections, the disclosures are really vitally important, and the substantive protections that go with them, and your continued focus on what actually happens in the marketplace will be vital.
Thanks, Will. This next question is for Michelle. Michelle, what can the mortgage and title industry do to work better to foster innovation and promote greater market efficiencies?
That's an interesting question. Thanks, Zixta. I think we all know that anytime you're looking at change, as I mentioned, you're looking at some pain. And it's very hard to not look at kind of the pain of change without realizing that the important thing to focus on is the opportunities that come anytime there's real change. And for our members, we've been very active trying to reach out to industry partners and others in the process to talk about how we can better communicate to serve our customers seamlessly. I mean, one thing that we know is that from the homebuyer's perspective, once I've bought a house, I'm basically working with the same company, usually in their minds, the lenders, until I get the keys to that house. And so while that may not be the reality, that they're working with different companies, I think it's very important that we look at the process of communicating seamlessly so that for their experience, they have consistent information that's very transparent and very accessible. And I'm really impressed with the work that's being done under an organization called MISMO, which works to set industry standards, where ever since you've started the testing on the forms, they've been looking at those possibilities and how to create some of the back office functions that will allow that really seamless process to be apparent to the consumer so that the home buyer has a much better experience.
Thanks, Michelle.
Great. Bernie, how have the products and services that your credit union offers changed since the onset of the financial crisis?
We actually expanded our product offerings, especially in the mortgage area, pretty much right in the midst of the crisis. One of the products that we introduced was we call the rescue loan, playing a little bit off the type of membership that I have with firefighters. We stepped up and allowed people to refinance mortgages up to 125% of the value of the property. Started this program in 2010, fairly quickly put about $10 million on the street. Commissioner, we did carefully underwrite these loans. Just so that I don't get into too much trouble here. But it was an opportunity
do you want me to talk to him for a
minute? Well, since you're now wearing a different hat, that might actually be a great thing. It gave us an opportunity to help some firefighters in a time of need. These are people who were doing the right thing. They were taking good care of their financial obligations, but they didn't have the same opportunity that many other people had to refinance their mortgages and come into the 3% and 4% area that everybody else was getting into because they were underwater. And we stepped up and we were able to help these people. We also stepped up with a couple of other consumer-related plans. One of the things we've done for veterans, and I know it's nothing to do with mortgages, but we're in a risk-based pricing environment. And yet for all of our Iraq and Afghanistan veterans, we price all of our consumer loans at our A+ rate in order to give our returning heroes an opportunity to consolidate debt and to improve their financial situation and get a new start. I'm concerned, though, a little bit that with the regulation that we're looking at, and in particular with some of the regulations that come into effect in January, and this goes back to my earlier comments, it's going to be more challenging to make these kinds of decisions because these type of products are potentially going to take a fairly simple institution like mine with fairly simple products and move us into some of the more complicated categories requiring additional compliance burdens. I had a meeting with my compliance attorney last week, and we really spent a lot of time on this topic and figuring out how we can still be this flexible and somewhat progressive lender and yet manage to comply with limited resources. Thank you.
Thank you, Bernie.
Great. Pat, this question's for you. Clear and understandable disclosures are important for consumers. That it's clear because that's what we're here today for. But wanted to ask you, what other parts of the origination process deserve attention to ensure consumers are protected?
These new disclosures are just one part of a whole package of reforms to the mortgage origination process. The importance of the disclosures is that it helps make consumers make better lending decisions. At the same time, originators can play a part in better lending decisions too. During the housing bubble, we all know that we saw a couple of dynamics that helped on the lender side push lenders into making loans that might have been too risky. Some originators could make more money by convincing people to take out reduced documentation loans, riskier loan products, and loans that had higher interest rates than the borrower qualified for. And in addition, securitization gave lenders some strong incentives to approve loans that borrowers might not be able to repay, and then pass that risk on to investors who had trouble figuring out what was going on. So there are now two new companion rules that help address these problems. One is the new ability to repay rule that requires originators to verify income or assets and make a reasonable determination of the borrower's ability to repay. This makes a lot of sense. Lenders have better information than loan applicants about the likelihood that somebody with a given credit profile and loan product will default, because they have big data. Everybody's talking about big data, but they have the ability to analyze that, and the consumer does not. In addition, the qualified mortgage provisions will give originators incentives to offer safer loan products with lower default rates to consumers. The other provision is the new mortgage loan originator compensation provision, which will help curb incentives to push consumers into costlier, riskier mortgages. My hope is, with consumers acting smarter and lenders acting smarter, that together we're going to have a much improved mortgage marketplace.
Thanks, Pat. This question's for Marietta, and it follows up slightly on what Pat just articulated. What are some of the areas of loan shopping for consumers that could be improved upon?
I think it's a good question. I think there are two main areas, and I think both of them will require some industry alignment and real focus on the consumer and being very consumer-centric. The first one is with regard to having everyone in the industry talk about mortgage products as they are mortgage products. Just like there are many kinds of toothpaste that we all shop for and we all have our special brand, I think that consumers need to understand that any given lender has a variety of mortgage products available to them, and that their loan originator is selecting what may best fit for them, but they're very empowered to shop and ask questions and push back and negotiate. And I think I was very heartened to hear Director Cordray's reference to new technologies, because I think new technologies can help consumers and borrowers really shop for a mortgage as a product, as opposed to what's my fastest pathway to a yes? How can I get a yes because I've already fallen in love with the home and I've already pictured my children going to that school. So how do you really shop? And I think that requires industry alignment. The second thing I would say is also very consumer-centric and requires alignment is, particularly for first-time home buyers, low, moderate income buyers, which is, a focus of my organization, there will be a lot of different products out there offering assistance in terms of down payment assistance, other kind of financial products that will be coupled to create the financial package. And having alignment with these new regulations with consumer development financial institutions, CDFIs, or other nonprofits making subordinate mortgages behind these products will require some alignment and will help that consumer shop for the financing package that is best for them. So I think there's a role for technologies there, but I think everyone has to be very focused and aligned on the consumer and how to put that package together best for them.
Thanks, Marietta.
Great. So I have the last question. It's for our industry members. And Marietta, I want to build off of one of the points that you made relative to the potential of new technologies. And for our folks to my right, I guess the question is, what's next, or where do we go from here? And what opportunities are there for the Bureau to work with industry to continue to improve the loan application process? What opportunities remain for innovation?
I'm happy to start.
Sure.
So from our perspective at the settlement side of the transaction, we really think about, kind of what does that look like for the consumer? And the Bureau talks a lot about how usually it's a big stack of papers and it's very scary. I think there's a lot of opportunity for a real advancement in e-closings, electronic signatures being used, having these electronic documents in process, and what that will do, just the usability, the ability to focus in on the very specific information that those consumers need and not spend as much time worrying about the stacks of documents that are in front of them that they're going to have to go through and sign. I think that's got real opportunity right now to be something that we really push to advance in the marketplace to the benefit of the consumers.
My comments go in two directions. One is to continue on Michelle's comments, and earlier we heard people talking about what are the concerns at the closing table. The biggest concern that I have at the closing table is that a closing package is about 2.5 inches thick. And the attorney comes with a package and just flips papers, and consumers just sign papers, and I don't think anybody really knows what's going on. This is certainly a case where less is better. I think there are many pieces of that package that have very little bearing on the transaction. They're put in because of different laws that are in place and different protections for the institution against various liabilities. And I think if we could find a way to make this package have more valuable information, but maybe a third or a quarter of the paper content, then we could make everybody's life a lot easier. My second comment is that on behalf of credit unions and I think community banks throughout the country, we didn't start the fire that created this massive regulation. And sometimes we're the ones who feel the brunt of what happens when regulation after regulation after regulation comes our way. I just once again urge the CFPB to be cognizant of who we are, what our role is, what our role was prior to the crisis, and the good things that we do in our communities every single day, and to be as cognizant of that as possible going forward.
So I just want to continue the trend of my industry colleagues here and say that I think one immediate next step would be to focus on improving consumer experience in the transaction. I think at least in the short term, there should be additional and increased consumer outreach and education on the significant changes that will impact the application process in 2014 and 2015. I think that everyone in this room is completely aware of what we've been dealing with the last couple of years. I'm not sure if consumers outside of this room know what's going to happen, not only in terms of the other regulations. We've got QM, whether or not someone who might have been approved in 2013 won't necessarily meet the requirements for that rule in 2014. And so here's a likely scenario with respect to the forms that I think could play out. So let's say we have a consumer that applies for a loan in December of 2014. They've asked about, as you brought up, multiple loan products, and we provide them just with one closing disclosure, or excuse me, one disclosure package. They decide not to do it, and 8 months, 9 months later, September of 2015, they decide to reapply, and suddenly they ask about the same mortgage products, and we give them multiple disclosures. Now, I'm not sure if the rule will address this. We certainly raised it in our comment letter, but that's a concern for us. Is how will requirements to provide multiple disclosures impact the consumer experience? And so, while I commend the Bureau for providing the industry with adequate time to implement the rule, I think this is really an opportunity for both the Bureau and industry to help prepare and educate consumers on these massive changes that are just on the horizon.
Great, thank you very much. So at this time, I'd like to ask all of our panelists to rejoin the audience, and for everyone in the room, please join me in thanking our panelists for the thoughtful comments.
What a terrific conversation. Thank you to the guest panelists. While the guests rejoin the audience, I want to call your attention to the screen, which will preview the Bureau's upcoming initiative, Know Before You Owe, Transforming the Closing Process.
Over the past couple of years, we've engaged in several Know Before You Owe projects, from credit cards to student loans to our newly integrated mortgage disclosure forms. We are committed to making strides to improve how consumers make major financial decisions. So next up, Know Before You Owe, Transforming the Closing Process. The current closing process on a mortgage is often burdensome for lenders and overwhelming for consumers. Anyone who has sat through a closing may remember that endless stack of documents and signing your name over and over, often not understanding all the things you're signing. Mortgage closings are complex. There are many players involved, from realtors and settlement agents to borrowers to sellers and lenders. All have different roles in the process. All parties weigh in, they sign documents and send copies. The process often faces delays caused by errors in documents and waiting on the various players to go back and forth. This often leaves a race against the clock to finalize the many items for closing. And in this frenzy, time pressures can cause some consumers to overlook issues that have lasting effects on their finances. We believe we can find ways to vastly improve the closing process for both lenders and consumers. We can do this through technology and through electronic or paperless closings. We believe that before consumers sign on the dotted line, they should understand what they are signing and feel comfortable about it. With today's technologies, lenders and consumers can save time and money by creating a more seamless, transparent, and educational closing process. We envision a system where consumers can log in and have a program coach them through a closing process. A system that provides them with time to review documents online in the comfort of their own home. A system that uses technology to help answer questions and define unfamiliar terms. A system that makes it easy for borrowers to quickly see changes and compare them to the original offer. We see all of these possibilities and are ready to explore them further. And to those companies out there already using electronic documents and other innovative ways to revolutionize the closing process, we want to hear from you. How are you improving and simplifying the process? What barriers to wider adoption still exist? So as we launch our Know Before You Owe, Transforming the Closing Process initiative, we'll be reaching out to you. We're making a commitment to playing a leading role in transforming the closing process for consumers and industry stakeholders alike.
And we're not quite done yet. Now it's time to hear from you all. A number of audience participants have signed up to share comments and observations about today's discussion. The open mic part of the field hearing is also an important opportunity for the CFPB to hear from you all about what's happening in consumer finance markets in your neighborhoods, in your communities. And it's also your opportunity to provide some feedback about the discussion and presentation you've just heard. Each person who signed up will have 2 minutes to offer remarks, observations, and feedback. What we hear from you is invaluable, and we want to hear from as many of you as signed up to testify today. So I ask you to please observe the 2-minute limit so that everyone has the opportunity to share their insights with us. Our first audience participant is Nadine Cohen. She's with the Greater Boston Legal Services.
Thank you, Zixta. I'm very honored to have this opportunity to make some comments, and I just want to congratulate the CFPB. There were many of us who were concerned that not being a full agency would limit the Bureau's effectiveness, and I'm very pleased to say that that is not the case. So we are very pleased with a lot of these regulations and forms, and if in fact they were in effect in the early 2000s, many of the people that I represent would not have needlessly lost their houses. I'm the managing attorney of the Consumer Rights Unit at Greater Boston Legal Services, and we represent low-income homeowners in foreclosure cases. I wanted to just focus for 1 minute on issues related to loan modifications, particularly the dual tracking issue. Clearly, the situation has improved, but I think that there can be regulations that are strengthened. Dual tracking is when people are being considered for a loan modification and at the same time have a foreclosure proceeding brought against them. We would like to see that foreclosures are stopped upon the submission of an initial modification application, and that it not be required to be a complete application because this is a moving target often.
Thank you, Ms. Cohen.
I will submit the rest later.
Please do. Mark Savitt with NAIHP.
First, I'd like to thank you for holding this hearing today. I have a lot of questions, but we have the 2-minute rule and some comments, so I'm going to adopt the suggestion of Mr. Grossman.
Thank you, Mr. Savitt.
Mr. Grossman's father, and use this instead of too much of this. First, I would like to thank you for these forums. I see Pat McCoy up there. I was fortunate enough to work with Pat in the beginning when we started the stakeholders roundtable with these forums. The CFPB, I know, worked very hard on this. We're very happy to see these new forms to be implemented, even though they're 21 months away. We know that the forms that we have now really aren't working. We knew this way back even before they went into implementation when HUD said, don't worry about it, this is simplification, and we have a form that explains the form. We knew we didn't have simplification. So we knew we were going to have a problem from day one. Just a couple of things here. We talked about the testing. I think you did a great job with testing. Of course, the real testing will come into effect when this goes into implementation, and we see that whether these forms have to be tweaked, and we hope that the CFPB will look at this also as a work in progress, and if things have to be tweaked, they would take that into consideration. Last thing I want to mention is something that Pat said before, talking about transparency. We believe in transparency, and that one of the best ways to give the consumer the tools that they need to make sure they do pick the best loan option for themselves is to have equal disclosure. And we've been saying this for years with our association, equal disclosure. Everyone should disclose in the exact same way on the exact same forms. And we're almost there. We have the exact same forms. So we asked the CFPB to make sure that all originators are giving the consumers the same information. Thank you very much.
Thank you, Mr. Savitt. Tim Armbruster with Closing Corp.
This is Tim. I just had a simple question. You mentioned that the CFPB may be involved in the implementation of these forms. How does the CFPB plan to help the industry in implementing these forms? Whether it's forums, standards, technology.
I don't know if this is on or not. Yep. We're going to approach this similar to the way we approached our main mortgage rules, and it's actually going to become, I think, pretty much a way of operating at the Bureau when we pass new rules. We will continue to begin with, we take questions, comments, and further input from everybody. Rich and his colleagues, do that extensively every day. We will be putting out, plain language guides, perhaps video guides, other things. As was just featured in the video that you saw, we're very interested in working with industry on simplifying the closing experience for consumers through technology. We think there's a tremendous amount of potential there. Some of it is already starting to be done, but I think it's important for the regulators to give it a blessing and a push, which we're interested in doing. And I guess the main philosophy here is, although we finalize these rules, they don't take effect for 21 months, and there will still be plenty of time for people to talk to us, and if we need to make some changes in the rules to facilitate compliance, or if we think we got something said something clearly, but it turns out you think we didn't, or you show us an ambiguity that creates potentially legal issues or concerns or uncertainties for you, just as we did with the main mortgage rules, we will consider addressing those matters further as we go. We recognize that we can write rules, and hopefully we write very good rules, and we do it with a lot of input, and that gives us some assurance that they are good rules. But if people don't actually implement them well, that's not good for you, it's not good for consumers, it's not good for us. We want to see that happen. We're happy to work alongside you to make sure that does happen.
Michael Coleman with NAFCU.
Good afternoon. I'm Mike Coleman, the Director of Regulatory Affairs for the National Association of Federal Credit Unions. First, I'd like to thank Director Cordray and the CFPB for conducting this hearing and allowing me the opportunity to provide some feedback. NAFCU greatly appreciates that the CFPB continues to engage in discussion with credit unions and other industry stakeholders as they're doing today in relation to their regulatory actions. We'd like to submit a letter for the record, and I'll make a few very brief comments and reiterate a couple of the other points that the panelists brought up with relation to the final rule on behalf of our members. First, I'd just like to mention that NAFCU supports and advocated for the combining of these two disclosures under TILA and RESPA, which we believe will benefit both credit union members and the industry in general. And we also appreciate the CFPB's willingness to meet with us and our members prior to and during the rulemaking process. It was a great effort on your behalf to bring the conversation to the forefront. In the finalization of the rule, we're glad that CFPB has heard our concerns regarding the more inclusive definition of the finance charge, the disclosures on the total cost of funds, and the definition of the business day. The last item, as minor as it may seem to many, is significant for small credit unions because many don't have operations on Saturdays, backroom operations on Saturdays, and the addition of Saturday in that definition would have resulted in significant costs to small credit unions. We continue to have some concerns about the general requirement to provide the closing disclosure 3 days before consummation, but we'll have to take a closer look and review the flexibility afforded in the final rule more closely. And we are also continue to be concerned about the more stringent approach to tolerances. Lastly, I'd just like to say regarding the regulatory burden and the compliance costs in relation to the implementation of the final rule and compliance solutions, I'd like to thank Director Cordray and Deputy Director Antonakis about your comments with regards to the continued efforts and communication and outreach between the CFPB, credit unions, and the industry in general.
Thank you, Mr. Coleman. We'd be happy to take your statement for the record. Christine Snow with the Massachusetts Division of Banks. Let's try Lisa Lugauskas with Fidelity.
Thank you. Very quick comment. Seems the focus today has been on the mortgage application process and the closing itself. It would be nice if the Consumer Financial Protection Bureau also protected consumers after the closing, and of course my industry is the title insurance industry. So as Michelle said, I'd like to see a greater emphasis on borrowers being made aware of the importance of an owner's title insurance policy. The lenders are afforded that coverage, but owners are not. It is the largest purchase they'll ever make, and the one thing that protects them after the closing is the owner's policy.
Thank you for the comment. Ruth Dillingham of Alta.
Thank you. The American Land Title Association has a task force to implement this rule on which I sit, and the comments that we have shared among our task force can be summarized as, please keep the door open. We anticipate there will be regional issues that will arise as we grapple with feet on the ground implementation and the integration among our various groups, the software providers, the closing attorneys, the settlement agents, the title agents, the underwriters. All of us are going to be trying to integrate among our business areas, and we really have appreciated your open ears up till now. We hope for the same open ears going forward, and that any information you provide back to the industry be transparent across all sizes of business ventures, from the smallest title agent in the smallest town in the smallest state to the largest bank in the largest city. Thank you.
Thank you, Ms. Dillingham. Nico Nicholson. Do we have Christine Snow? Okay, that concludes the CFPB's field hearing in Boston, Massachusetts. Thank you for taking the time to join the CFPB today, and thank you to all who joined by live stream. Have a great afternoon.